Alex Cartledge, and I will be attending the University of San Diego.
My name is Atlee Means, and I will be attending the University of Mississippi.
My name is Sophia Burgoyne, and I'll be attending Northwestern University. Our unit coach is Mr. Scott Daniel, and our teacher is Mr. Richard Clark.
I will begin with reading the question. No man can set his foot upon his neighbor's clothes without his leave. If he does, he is a trespasser, though he does no damage at all. If he will tread upon his neighbor's ground, he must justify it by law. Do you agree or disagree with Lord Camden's statement? Why? Under what conditions, if any, should the government be able to search or seize your property? What fundamental rights, in addition to privacy, might be jeopardized by government searches and seizures of personal property? Explain your position. Under what conditions, if any, should individuals agree to limit their right to privacy in order to promote the common good? Explain your position.
In Commentaries on the Laws of England, William Blackstone wrote, "What is more sacred, what more strongly guarded by every holy feeling than a man's own home?" Such ideology helped foster the Castle Doctrine, promoted by Lord Camden and N.T.P. Carrington. These reflect the ancient principle of individual property, which directly influenced the creation of the Fourth Amendment and has been translated to our modern concept of the fundamental right of privacy.
We agree with the precedent ingrained in NT that the act of trespassing, even without harm, is still an invasion of privacy, and that one's property should be protected by written rights. Lord Camden influenced the current warrant process by advocating for specified warrants that were signed by an officer instead of a monarch. This established the rule of law that the government cannot act in executive capacity. Thus, they cannot exercise public power unless such exercise of it is authorized by some specific rule of law. The idea of self-defense in Camden's reference of tort law can also be seen in current standard ground laws across the nation. We agree with Nevada's proclamation, in which an individual is able to defend oneself if the danger is so urgent or pressing that they have to kill another person to save themselves. Yet we acknowledge that some of these laws are flawed in nature. That some of these laws that resulted from Camden's promotion of tort law are flawed in nature. Most people are not aware to what degree they're allowed to defend themselves legally.
In Detroit, Theodore Wafer used self-defense to justify shooting unarmed Renisha McBride, who was on his porch asking for help after getting in an automobile accident. We also disagree with Camden's statement that, if it is law, it will be found in our books. If it is not found there, it is not law. This claim doesn't coincide with the Fourth Amendment, in which privacy isn't explicitly stated, but rather implied through penumbras and emanations.
When justified by law, as highlighted by Camden, the government has the ability to search or seize one's property. In the 1983 case Illinois v. Gates, the court ruled that government officials have probable cause to request a warrant when they possess anonymous letters detailing possible illegal activity. Additionally, in cases of criminal asset forfeiture, the government has the permission to seize property if it is related to a crime. In Austin v. Texas, Richard Austin was charged with 4 violations of South Dakota's drug laws and had his mobile home and auto body shop seized as a result.
Furthermore, civil asset forfeiture is also an instance where liberty can be jeopardized as a result of the government seizing property without a warrant due to a hunch that someone has or is going to commit a crime. In 2015, Joseph Rivers switched trains in Albuquerque, New Mexico, with an envelope filled with $16,000 with help from his family in hopes to produce a music video. During a random police search, the money was confiscated after it was suspected to be intended for illegal purposes. The DEA agent in charge of the Albuquerque office stated that the DEA doesn't have to prove that the person is guilty, but instead that it's that the money is presumed to be guilty. Such disregard for property rights in civil asset forfeiture has led to the fundamental rights in the Seventh Amendment being disregarded as well. While most invasions of privacy are frowned upon, Megan's laws are useful in determining the extent to which privacy should be limited for the public good. These laws were inspired by the death of 7-year-old Megan Kincaid, who was raped and murdered by her neighbor who had been convicted of sexual assault twice previous to Kincaid's death. Megan's law requires authorities to notify communities as to the whereabouts of sexual predators in hopes to prevent deaths and assaults like Kincaid's, with sites such as Watchdog and Open Records where such predators are living.
Privacy is one of the most sacred rights, as it not only protects an individual's belongings, but also their thoughts, beliefs, and most intimate perceptions. Author Albert Camus wrote, "Opt for privacy and solitude. That doesn't make you antisocial, but you need to breathe and you need to be." Fourth Amendment protections are necessary because they protect a person's right to be and express who they are without governmental intervention. Thank you.
what extent may a person go to protect his or her property if someone comes on the property on a trespass?
In Nevada, the stand your ground statutes that are set in place allow a person to protect themselves and their belongings if a person comes onto their property with the intent of causing harm or with the intent of stealing something. This can be seen in the case that we cited in our testimony, in which someone came up to the house that the person was living in, and they asked for an automobile accident or about an automobile accident, but then they tried to steal something, and the person was then able to defend themselves legally.
How about a spring gun placed inside of an empty cabin that will go off when someone opens the door with the intent to come inside? Is that lawful?
Well, you can argue that if the person is not being the aggressor and if a government official is coming with a warrant, which isn't an aggressive act necessarily, that it wouldn't be protected stand your ground law under Nevada's proclamation as a colleague of
The Fourth Amendment is not absolute in its protection of privacy. Can you tell me what is meant by the phrase probable cause for the issuance of a warrant?
Probable cause is a level of scrutiny in which a governmental official has to meet in order to be able to obtain a warrant. The other two are the other one that's used inside of schools usually is reasonable suspicion, but probable cause means that you have to have evidence, or you have to present it to a judge, and they have to actually believe or have an intent of giving you a warrant because of that evidence.
It also has to be close to beyond a reasonable doubt that the illegal activity is occurring, or that illegal substances or other things are in the area that you're required to search warrant for.
Let's shift gears to some specific situations. So the police suspect you of having committed a crime, they detain you, you've got an iPhone on you, and they want to search the phone. Can they do that?
As established in Randy, California, the government still needs a warrant in order to search your cell phone. While they may seize your cell phone in order to, your passcode still has the same precedent as a lock, and it's important for the government to still get a warrant in order to seize what is inside.
Okay, so they get a warrant. They now have a warrant. Your phone, as you just noted, has a password on it. And they compel you to give up the password or protect it with a phone.
Yes, if they have a specified warrant for the phone, yet they would have to look for the specific information that they are looking for in the phone, seeing as that there are multiple apps and multiple effects, as you would call it, that are already within the Fourth Amendment.
This can be seen or applied to colonial times, in which the colonials were against general warrants or people simply going into someone's house to search for one thing but then searching everything. If the government has a warrant to search your phone, that warrant has to be specified, and that warrant they cannot search everything on the phone but only the thing that's specified within that warrant.
Last follow-up. What happens, what if instead of a password, I use my thumb to unlock my phone? Can they force me to give up my fingerprint or put my thumb on the phone?
This is where this gray area comes in, where there hasn't been a precedent set yet. It varies between states. I know Minnesota has allowed police officers to force people to put their thumb on their phone without a warrant, but an incident to arise, which is seen as a violation of privacy through Riley v. California. Usually, because it's a thumbprint and not a direct code, there's debate as to whether that's an invasion of privacy.
Specifically.
We have another minute. Let's assume that you're 16 years old and you are in your parents' home and the police come to the door. You knock on the door, they talk to your folks, they want to look around, they don't have a warrant, your folks say, fine, you can look around. Your bedroom door is closed and you object to the police going into your bedroom. Should that evidence, if there's contraband found in your bedroom, may it be used against you?
No, you have a reasonable expectation of privacy through closing your door. This was established in Katz v. Wetz, in which a man closes the front door behind him and established his expectation of privacy. So if your parents allow the man into the home, you do have that reasonable expectation of privacy, no matter your age, especially since it's not on school grounds.
make a difference that your parents actually own the physical property?
It does make a difference. In cases of automobiles, if you are the one driving the car, but there's illegal contraband found in the automobile, that contraband is associated with the license, not necessarily the licensed driver, but the registered driver of the vehicle itself.
The police officer used a drug sniffing dog outside your home without entering.
Without a what?
Without entering the home, he's got a drug sniffing dog with him that says, I think there's something in it. I smell something.
No, it's established in Illinois v. Tobias. It has to be within plain sight or plain smell. The police officers cannot go within intent on private property, including a house, to use a drug dog unless they have reasonable suspicion or a general or warrant to do so.
But if it's like just a super sniffer dog and it can just walk on the public sidewalk and smell out marijuana grows in houses, why can't they just walk up and down every street in America?
I'm going to disagree with that, Claudia, interrupt you briefly. Line of smell is the dog, so they are allowed to do that in some situations, yet it's stopped at the sidewalk.
Did you call that? Just, thank you.
Round of applause.
Very nicely done. Your opening statements were clear. You made good transition to your opening statements. I was interested that on the extent of your focus on property. I mean, you focused both on persons and property, but you really focused in your opening statement on the protection of property, which I found interesting. And yet, I was impressed that when questions were asked that went away from your focus, your opening statement to different areas of Fourth Amendment law, that you were able to answer those questions and command of the precedent. Well done.
Yeah, I would agree. I thought you did a nice job in all aspects of the discussion. I didn't hear a ton on the first sub-question, I guess, what rights in addition to privacy. You know, I heard the Seventh Amendment and you talked a bit about civil forfeiture, but I might have liked to hear just maybe a little bit more. I think we got into it in the Q&A, you know, the potential self-discrimination concerns, even First Amendment concerns. I think you do it. I just didn't hear it quite as clearly as I might have. On the Q&A, I thought you guys did a nice job. I thought our cell phone discussion was a good one. I mean, I think Atlee is absolutely right. It's a gray area. The whole thing is a giant gray area, and it's very difficult. And one line the courts have been drawing is between giving up a password, which they're viewing as potentially self-incriminating and protected by the Fifth Amendment, versus a thumbprint, which doesn't communicate anything. Right? It's just a part of your body that may already be in the police files. And so some courts are saying, yes, give up a thumbprint, no password, and vice versa. It's going to be an interesting thing. So, nice job.
I too was very impressed with how hard you have worked this semester and indeed even that year. You've got to command the concept of privacy. You've got to command the right to be left alone, as stated in Homestead. I think your ability to use specific case decisions to back up your positions was very impressive. I congratulate you on your hard work this year, and good luck in the competition.